I reviewed Jennifer Kern versus Halbrook Excavating. This was a claim of discrimination, pregnancy discrimination, and sex discrimination. Jennifer Kern had told her employer, HR representative, that she was pregnant, and they didn't really know how to react. Or not react, but they had said that they had never had a pregnant employee before, but they would work with her to make sure the FMLA was covered, her time off was covered, etc. It happened that Jennifer ended up getting fired because the company was downsizing, or I'm sorry, not fired, she was laid off, and the company was downsizing. Jennifer filed a petition saying that she was discriminated because she was pregnant, and the company had also laid off a couple other workers that were male in similar positions, and another employee that was in a similar position moved out to the field. And after Jennifer was laid off, she was told that her position had been eliminated and her duties have been reabsorbed into other positions in the company. The company was hiring for field positions after that, so something she didn't do. She also had a few disciplinary issues on her record involving errors in her bookkeeping that totaled more than $10,000. She'd been doing some personal things on the computer that she had been talked to about. So aside from that, she was not, the court ruled she was not discriminated against. The thing I would suggest, the company well documented all of the incidences and that the mistakes that she had made and the money, her personal contacts on Instant Messenger while she was at work. The thing I would do differently is when Jennifer had the conversation with the HR rep that she was pregnant, I would have had another witness for that conversation. I would have had a document drawn up, a written agreement, and the ways that the company would work with her to make sure her leave was taken care of, etc. in that way, because it was a lot of word of mouth coming back and forth between Jennifer and then the HR rep. Jennifer said that the rep said her being due in July was, not convenient for the company, and they didn't know how that would work. The rep said that Jennifer had expressed that instead. So just having that extra witness, having the documentation, having it signed off that both parties agreed, would just eliminate a lot of that questioning there. The court ended up ruling that Jennifer was not discriminated against, and that's something I would agree with based on her position being eliminated. And it's just unfortunate that she happened to be, pregnant at the same time, and given I guess she had the illusion that it was because she was pregnant, but the facts presented in the case really prove that not to be the situation.